If you own a gun in America, everything you thought you knew about your rights just changed. A federal appeals court dropped a bombshell ruling this March 2026 that is rewriting gun laws across the country right now as you watch this. There are 8 massive changes in this decision, and some of them are going to shock you. These changes hand you new freedoms while simultaneously creating legal traps that most gun owners will never see coming until it is too late. Hit subscribe right now because missing even one of these could cost you everything. Here are the 8 changes every gun owner must know immediately. Law 1. Strict scrutiny as the mandatory standard. This first change is the foundation that makes everything else on this list possible, and it completely flips how gun laws work in America at every level of government. For decades, courts allowed the government to pass gun restrictions without ever proving those restrictions were actually necessary. All the government had to do was point to public safety as a general concept, and courts would waive gun laws through with minimal scrutiny. That era is over. The March 2026 ruling confirms that every single gun law in this country must now pass what is called strict scrutiny, which is the toughest legal test that exists in American constitutional law. Courts apply strict scrutiny to the most fundamental rights. Freedom of speech gets strict scrutiny. Religious freedom gets strict scrutiny. Racial discrimination claims get strict scrutiny. Until now, gun rights were treated as second-class rights that got a weaker, easier-to-pass standard. That double standard is gone. Anytime the government wants to limit your gun rights going forward, they have to prove 3 things simultaneously. They need a truly compelling reason, not just a good idea or a general preference. That compelling reason has to be proven with actual evidence, not just asserted. And the law they pass has to be narrowly tailored, meaning it cannot be broader than absolutely necessary to address the specific problem. The government now carries the full weight of proof. This puts thousands of gun laws across the country in serious danger of being thrown out, and the legal challenges are already being filed. But here is something even more critical that affects your wallet directly, and almost nobody is talking about it yet. Law 2. Civil liability shield for lawful defense. If you ever have to use your gun to defend yourself or your family, this next change could literally save you from financial ruin. Because for years, people who successfully defended their lives with firearms still got destroyed in civil court afterward. A man in Ohio shot a burglar who broke into his house at 2 in the morning. No criminal charges were filed. The evidence was clear, but the burglar's family sued him in civil court and won a $400,000 judgment. A woman in California defended herself from an attacker in a parking lot. She did everything right, but the attackers sued her for $1.2 million, claiming excessive force. These lawsuits destroyed people's financial lives, even when the legal system confirmed they acted justifiably. The March 2026 ruling creates absolute immunity from civil lawsuits when you use a firearm in lawful self-defense. The criminal who attacked you cannot sue for their injuries. Their family cannot sue on their behalf. The burden is entirely on anyone who tries to bring a civil case against you, and they have to prove your actions were criminal before a civil case can even begin. Not questionable, not debatable, criminal. This is a complete reversal of how it worked before. Before this ruling, the civil lawsuit was essentially automatic, and you had to defend yourself and your finances at the same time you were defending your freedom. Now, the civil route is blocked unless a criminal court first finds your actions were unjustified. This protection is real, and it is immediate. But there is another change that determines whether police can even take your gun in the first place before any of this matters. Law 3. Law Enforcement Accountability Standard. Police officers who violate your gun rights are now facing consequences they never had to worry about before. And the change is significant. For decades, something called qualified immunity protected officers from personal financial responsibility, even when they clearly broke the law. The doctrine said that unless your specific right was established beyond any debate in prior case law, the officer was shielded from personal liability. For Second Amendment violations, specifically, that shield just shattered. Under this March 2026 ruling, officers can no longer hide behind qualified immunity when they violate clearly established gun rights. If they take your legally owned firearm without probable cause, they face personal liability out of their own pocket, not just department liability. In Virginia, just last month, An officer confiscated a man's concealed carry handgun during a routine traffic stop. Even though the man had a valid permit and had properly disclosed that he was carrying, the officer had no legal basis for the confiscation. That officer just lost a $300,000 personal judgment. Not the department, the officer personally. That kind of personal accountability changes behavior in ways that departmental policy never does, because it is now the officer's own financial future at stake when they overstep on gun rights. But there is a specific type of place where the rules just changed just as dramatically. Law 4, sensitive place restrictions dramatically narrowed. The government's favorite trick for banning guns everywhere while pretending not to ban them just got shut down hard. States like New York, New Jersey, and California figured out a clever legal workaround after the Bruin decision. They could not ban guns entirely anymore. So, they declared almost every public location a sensitive place where firearms were prohibited. Some states had lists with over 50 categories of banned locations: grocery stores, public sidewalks, parking lots, movie theaters. The lists were so broad that gun owners with valid carry permits had essentially nowhere they could legally carry and practice, even though they technically had a permit. The permit was real, but the places you could use it were nearly non-existent. The March 2026 ruling destroys that strategy completely. The court established a strict two-part test for what actually qualifies as a sensitive place. First, it must have genuine security infrastructure in place, meaning metal detectors, security screening, armed guards, or some combination of real physical security measures. Second, the security must be sufficient to actually protect people inside. A courthouse with metal detectors and armed security personnel qualifies. A school with active security screening and on-site law enforcement qualifies. But a public park with nothing but a sign that says, "No guns" is not a sensitive place anymore. A shopping mall with a sticker on the door is not a sensitive place. Private businesses can still ask you to leave if they discover you are carrying, but they cannot have you arrested simply for being present with a legally carried firearm. States are now being forced to slash their sensitive place lists by 80% or more. And in many states, the legal process of doing that is already underway. Law 5, Carry Permit Processing Timeline. Enforced. The bureaucratic game of delaying your rights until you got frustrated and gave up just ended, and the end came with teeth. For years, states with restrictive gun laws had a simple and effective strategy for limiting carry permits without technically denying them. They would receive your application and then simply sit on it. 3 months would pass. 6 months a year. New York had carry permit applications sitting pending for an average of 18 months. During that time, you have no permit and no rights. The longer they delayed, the more people would grow frustrated, move, get busy, or simply abandon their application. The delay was the denial. Every state must now approve or deny your carry permit application within 60 days of submission. Full stop. If the state fails to respond within that 60-day window, your permit is automatically approved by operation of law. States cannot request additional documents after you have submitted your application unless they identify a specific legal deficiency in writing within the first 2 weeks. The 60-day clock starts the moment they receive your application and nothing stops it. If your application is denied, they must provide a detailed written explanation citing specific legal grounds, not vague concerns, specific cited legal grounds. Several states are already reporting they have approved more carry permits in the last 3 weeks than they approved in the previous 6 months combined, because the automatic approval provision means delay is no longer a viable strategy for suppressing permits. Law 6 ammunition storage mandates struck down. The laws that were specifically designed to make your gun useless in an actual emergency just got wiped off the books entirely. Several states had passed ammunition storage requirements that sounded reasonable on the surface, but were engineered to defeat the entire purpose of owning a defensive firearm. Massachusetts required ammunition to be stored in a locked container completely separate from your firearm at all times. California mandated that ammunition be kept in a different room from your gun. A county in Illinois required firearms and ammunition to be stored on different floors of your home. Think carefully about what those requirements actually mean in a real home defense situation. You hear glass breaking at 2 in the morning. You go to your safe and retrieve your firearm. Now you have to leave your bedroom, go to another room, unlock a separate container, retrieve your ammunition, return to where your firearm is, load the weapon, and then respond to whatever is happening in your home. The person who broke into your house is not going to wait patiently while you complete that process. These storage requirements did not make homes safer. They made defensive firearms functionally useless for the only purpose that justifies having one. The ruling is direct about this. Ammunition storage mandates that prevent or materially delay immediate access to a loaded defensive firearm violate the Second Amendment because they render the firearm ineffective for self-defense. You have the right to store your firearms and ammunition together in whatever configuration you determine makes sense for your personal and family security. Law 7. Firearm Registry Prohibition Enforced. The gun registry that was never supposed to exist just got exposed and ordered destroyed, and the timeline for compliance is not optional. Federal law has explicitly prohibited a national gun registry since 1986. The law is clear. It is illegal for the government to maintain any system that tracks which specific firearms are owned by which specific people. But several states found creative workarounds that accomplish the same thing under different labels. California's dealer record of sales system quietly accumulated information on every handgun purchase going back to 1996. That is over 20 million records directly linking specific named individuals to specific firearms by make, model, and serial number. Hawaii required every single firearm in the state to be registered with local police, including complete owner information. The March 2026 ruling addresses these systems directly and with no ambiguity. Any state-level database that tracks individual gun owners or links specific firearms to specific people is illegal. It violates federal law. These systems must be completely and verifiably destroyed within 180 days of the ruling. Every state that maintained these databases is required to send written confirmation to every affected gun owner confirming their information has been permanently and irreversibly deleted. Several states are already challenging this requirement in court, but the ruling made the consequences explicit. Noncompliance results in contempt of court charges and daily fines until the registries are eliminated. Law 8. Enhanced Castle Doctrine Protections. Using your gun to defend your home used to mean preparing for two separate fights. The first against the criminal who broke in, and the second against the prosecutor who decided to make an example of you afterward. Even in completely clear-cut cases of home defense, district attorneys in certain jurisdictions would aggressively pursue criminal charges against homeowners who shot intruders. The legal and financial consequences of defending yourself could stretch for years, even when you ultimately prevailed. A homeowner in Maryland shot an armed intruder who had broken into his home while his family was inside. The intruder had a criminal history that included prior violent offenses. The homeowner was arrested at the scene, charged with aggravated assault, and spent 2 full years fighting the charges before being acquitted. A woman in the same state shot an ex-boyfriend who kicked in her front door in direct violation of an active restraining order. She spent 8 months in jail before the case was finally dismissed. In both cases, these people did exactly what the law was supposed to allow them to do, and the legal system spent years punishing them for it anyway. The March 2026 ruling shifts the burden of proof in home defense cases entirely onto the prosecution. If you use a firearm to defend yourself in your own home or on your own property, prosecutors must now prove beyond a reasonable doubt that your actions were not justified self-defense. The presumption is in your favor. They have to overcome it. That is a fundamental reversal of how the burden worked before in many jurisdictions, and it changes the calculation for prosecutors who were using the threat of charges as leverage against people who had done nothing wrong. These 8 changes represent the biggest shift in gun rights we have seen in a generation, and they affect every aspect of how you own, carry, store, and defend yourself with a firearm. Strict scrutiny means gun laws have to actually justify themselves. Now, civil immunity means defending yourself does not open you up to financial destruction. Officer accountability means your rights have real enforcement behind them. Narrowed sensitive places means your carry permit is actually usable in the real world. Processing timelines means states cannot bury your application indefinitely. Ammunition storage freedom means your defensive firearm can actually function in an emergency. Registry destruction means the government cannot track your ownership through the back door. And enhanced castle doctrine means defending your home does not automatically make you a defendant. The difference between knowing these laws and being blindsided by them could literally be the difference between freedom and a courtroom. If this information just saved you from a legal disaster you never saw coming, smash that subscribe button right now and hit the notification bell so you never miss an update on rulings like this one. Share this video with every gun owner you know because these protections only work when people actually understand they exist. Stay safe. Stay legal.